Imagine a threat lurking in your own home, a silent killer that could permanently damage your child's brain, all while you remained completely unaware. This isn't a horror story. It was a devastating reality for millions of American families for decades. For generations, lead paint was the standard, adorning walls and windowsills with vibrant colors. But beneath that cheerful facade lay a deadly secret. The total cost of this health crisis, the damage to children, and the eventual remediation, it's estimated to be in the hundreds of billions of dollars, with one landmark case alone seeking over $1.5 billion in damages. But how did this widespread poison become so common? And what legal battle finally forced its removal from our homes? For much of the 20th century, lead paint was considered superior for its durability and vibrant pigments. Manufacturers touted its benefits, and homeowners loved how it stood up to wear and tear. However, the science showing lead's toxicity was not new. Ancient civilizations had already observed its dangers. By the early 1900s, medical journals in Europe and even the US began publishing reports linking lead exposure to severe health problems, especially in children. Yet, despite mounting evidence, the industry continued to produce and market lead-based paints, often downplaying or outright denying the risks. This deliberate concealment would later become a central point in the legal fight. So, who finally had enough? And what made this particular legal case so impactful? The story takes us to Santa Clara County, California, in 2000. Public health officials and attorneys, fed up with the ongoing crisis of lead poisoning among children, decided to take a stand. They filed a groundbreaking lawsuit against several major paint manufacturers, including Sherwin-Williams, Enel Industries, formerly National Lead Company, and ConAgra Grocery Products Company, which acquired W.P. Fuller Paint Company. The plaintiffs weren't just seeking compensation for individual victims. They wanted a massive public nuisance abatement fund. This wasn't about a single child, but about every child at risk in millions of homes. The goal was to force these companies to pay for the inspection and remediation of lead hazards in all affected homes across California, a monumental task that would require billions. But what exactly did the plaintiffs have to prove to win such an unprecedented case? The legal team faced an uphill battle. They had to prove not only that lead paint was dangerous, which was largely accepted science by this point, but also that the manufacturers were directly responsible for creating a public nuisance and had knowingly promoted a hazardous product. The plaintiffs presented expert testimony from pediatricians, toxicologists, and epidemiologists, detailing the irreversible neurological damage caused by lead exposure in children, even at low levels. They showed how lead chips and dust, especially from deteriorating paint in older homes, were easily ingested by toddlers. Evidence included studies linking lead exposure to lower IQs, behavioral problems like ADHD, and learning disabilities. This was a direct attack on the industry's historical practices, but the defense had powerful arguments of their own. The paint companies mounted a vigorous defense, arguing that the responsibility for lead paint hazards lay with property owners, not manufacturers. They claimed their products were legal at the time of sale, that the dangers of lead were widely known, and that intervening factors like poor home maintenance broke the chain of causation between their product and any harm. Their lawyers cited legal principles of assumption of risk and argued that removing lead paint was an unreasonable burden to place solely on them. Furthermore, they contended that the public nuisance doctrine was being misapplied, as their products were no longer actively being manufactured or sold for residential use. This was a complex legal dance, but the plaintiffs had a secret weapon: the industry's own historical documents. Perhaps the most damning evidence against the paint manufacturers came from their own archives. Internal company memos, meeting minutes, and advertising strategies spanning decades revealed a deliberate campaign to mislead the public about lead's dangers. Documents showed executives acknowledging lead's toxicity internally, even discussing alternatives, while simultaneously funding campaigns to downplay risks and lobby against regulations. For example, one company memo from the 1930s discussed the advisability of using lead-free paints for interiors, yet they continued to market leaded paints for all uses. This wasn't just ignorance. It was calculated deception. This evidence painted a picture of corporate malfeasance that was hard for the jury to ignore. But how would the court interpret the public nuisance doctrine in such a novel way? A crucial legal hurdle was the application of public nuisance. Traditionally, this doctrine applies to ongoing activities that unreasonably interfere with public health or safety, like a polluting factory. The defense argued that lead paint, once applied, was a fixed product, not an ongoing nuisance created by them. However, the plaintiffs successfully argued that the legacy of lead paint, its continued presence and deterioration in millions of homes, constituted an ongoing public nuisance that the manufacturers, by their deceptive marketing, had directly contributed to creating. The court agreed that the company's past actions were directly causing present harm. This reinterpretation was a significant legal victory, creating a precedent that could impact other industries facing historical product liability. But the companies weren't going down without a fight, leading to years of appeals. After years of litigation, including multiple appeals, the California Court of Appeal in 2017 delivered a bombshell. It largely upheld the lower court's finding that Sherwin-Williams, Enel Industries, and ConAgra were liable for creating a public nuisance. The court ordered them to pay a staggering $1.15 billion into an abatement fund. This money was specifically earmarked for the inspection and remediation of lead paint hazards in homes built before 1951 in 10 California cities and counties. It was a massive win for public health advocates and a stunning defeat for the paint industry. This verdict sent shockwaves through corporate America, demonstrating that manufacturers could be held accountable for harms caused by products sold legally decades ago, especially when they concealed known dangers. But what did this massive payout actually mean for the everyday homeowner? To give you a sense of scale, $1.15 billion is an immense sum. For context, typical lead paint remediation for a single-family home can range from $10,000 to $30,000, depending on the severity and scope. This fund aimed to address thousands of homes. The court specified that the money would fund proactive efforts, not just reactive responses to individual poisoning cases. This meant systematic identification and removal of lead paint hazards in older, high-risk properties, protecting children before they were harmed. For instance, if a county had 10,000 homes built before 1951, this fund could potentially remediate over 50,000 lead hazards at an average cost of $20,000 per home. This wasn't just a symbolic victory. It was a concrete plan to make communities safer. But even with this landmark ruling, a common misconception still leads many homeowners astray. Here's a common myth many homeowners still believe. If my house was built before the 1978 ban, but I haven't seen any peeling paint, I'm safe. This is a dangerous misconception. The federal ban in 1978 prohibited the manufacture and sale of lead-based paint for residential use, but it didn't magically remove existing paint from millions of homes. Even intact, lead paint poses a risk. When windows and doors are opened and closed, or when renovations occur, lead dust can be created and become airborne or settle on surfaces. This invisible dust is often a greater hazard than visible chips. Furthermore, children can ingest lead by touching contaminated surfaces and then putting their hands in their mouths. So, what steps should you take if you own an older home? If your home was built before 1978, the first step is to assume lead paint is present. Do not try to remove it yourself. Improper removal can release dangerous lead dust. Instead, hire a certified lead inspector to assess your home. They use specialized equipment to identify lead hazards. If lead is found, you have options: encapsulation, covering the lead paint with a durable material; enclosure, building a new surface over the lead paint; or removal. Always use EPA-certified lead abatement contractors. Failing to disclose known lead hazards when selling or renting an older property is a federal crime, punishable by civil penalties of up to $19,252 per violation. This mistake can cost you far more than just money. It can lead to serious legal battles and put lives at risk. But this trial had a broader impact beyond just California. The California lead paint trial, though specific to certain counties, had a national ripple effect. It strengthened the resolve of other states and municipalities to pursue similar litigation and push for more aggressive enforcement of existing lead safety regulations. It also raised public awareness to unprecedented levels, making lead paint a household concern rather than a niche health issue. The verdict reinforced the principle that manufacturers have a responsibility for the long-term safety of their products, especially when knowledge of harm is withheld. While the initial $1.15 billion ruling was later reduced on appeal to $305 million and applied statewide in California, its legal and public health impact remains monumental, paving the way for safer homes across America. This case fundamentally shifted the legal landscape for product liability and public health. But what does this mean for future cases of corporate responsibility? The trial that banned lead paint in America taught us a critical lesson. Corporations can be held accountable for historical harms, especially when they knowingly prioritize profit over public safety. The legal system, though slow, can be a powerful tool for public health reform, compelling industries to act responsibly. If you're wondering about the specific federal regulations that now govern lead paint disclosure and renovation, that's a whole other complex area. We covered the landmark legal case that forced the issue, but understanding the nuances of current federal law, like the Residential Lead-Based Paint Hazard Reduction Act of 1996, is crucial for anyone buying, selling, or renovating an older home today. Make sure to subscribe for more true U.S. legal cases and courtroom stories told simply.